Well, hey folks, Lori Daybell is back in the headlines after filing a fiery motion for a new trial in that attempted murder conspiracy case in Arizona. Yeah, the same one that she was just convicted of. So let's break down her latest legal filing, where she's accusing Judge Beresky of violating her constitutional rights by forcing her to defend herself while seriously ill, in her opinion. Hey, we'll dig into her claims, the court's response, and what this could mean moving forward. Does Lori Daybell really have a shot at retrial? Well, welcome back to Profiling Evil. If you're as obsessed with the twists and turns of the Lori Daybell case as I am, then you're in the right place. I keep wanting to look away, but it's like a slow-moving train wreck, and I have to keep looking back. But make sure you tap that like button down below and subscribe to the channel. And please share us with your fellow true crime sleuths. Now today we're going to go behind the headlines straight into Lori's latest courtroom maneuver. It's a motion that she filed asking for a brand new trial. And folks, she's not holding back. She's got claims of constitutional violations, and there's some eyebrow-raising courtroom decisions on this one. It's going to be packed. Now I want to jump right into the retrial motion. Lori just filed it, starting with her first claim of wrongdoing in the trial. She began with what she believes are violations of her Fourth Amendment rights. And kind of as a reminder to all of us, the Fourth Amendment protects us from unreasonable searches and seizures. So, in other words, the government can't just barge into your house, rummage through your stuff, and forcefully drag you out of bed without a very good reason. And usually it's a warrant. But this is the twist in this thing. Well, this also extends further, and Lori claims that something like that happened to her in court on May 30th when she fell ill during that jury selection. She says it was so bad that she was even heaving. She was just plain too weak to carry on. Well, despite notifying the judge, she was ordered to remain in court for what was supposed to be 10 minutes, but it turned into an hour and a half. Now keep in mind, these time frames are Lori Daybell's timetables. I don't know if that's actually accurate. I suspect it probably is. Court can be kind of slow at times. But the court may come back with a differing opinion on all of this, and I'm going to be waiting to hear what those are. But things escalated when Judge Beresky issued a series of by any means necessary orders that the jail needed to have Lori Daybell in court, no matter what her condition was. Well, on June 2nd, Lori claims she was so dehydrated that she couldn't walk. Now you'll remember that day because that's when she was wheeled into the courtroom in a jail-issued wheelchair. And if you don't remember that, go back, watch my earlier video on her dramatic entry and her in the presence of the jury and out of the presence of the jury performance, because they were two different performances. Now once there, she claims that the judge made her transfer into a regular chair rather than sitting in the wheelchair and insisted that she participate in the proceedings. Now that wasn't a one-time deal either. These orders, she complains, continued daily, dragging her into court even after she'd been diagnosed with an infection that required antibiotics. Well, adding to this legal firestorm, the jail's medical provider, a company called CHS, allegedly evaluated Daybell without her knowledge and shared that medical data with the court and the prosecution. Now, she says that violated her HIPAA rights. She said that info was even filed publicly at first without being sealed, and she's raising all kinds of cane over that. Now, her legal team argues all of this, saying they were forced into court while she was sick, that they had their medical records shared without consent, and that Lori was denied basic care while in holding. And she says all this adds up to a major violation of her Fourth Amendment rights and Arizona's equivalent constitutional protections. So that was the big thing that she went after. But then she leveled claim or violation number 2. She calls it a lack of judicial impartiality. Now, if you ask Lori Daybell, Judge Beresky isn't a fan of her, and that's putting it mildly. But here's the thing. A judge's job isn't to be her friend. It isn't to win popularity contests. It's not about liking or disliking the people in the courtroom. It's about fairness, balance, and making sure that the law is followed to the letter. And the irony, of course, is that Lori, while trying to play attorney, claims that she wasn't afforded the same respect for the rules that she spent years trying to twist. So in this latest complaint, Daybell argues that Beresky denied her a fair shake by blocking her ability to present a full defense. Now specifically, she claims the judge refused to let her argue objections, that he frequently denied her requests for sidebars, and didn't allow her enough time to consult with her investigator before cross-examination. And to back that up, she offered this one example from June 9th, 2025, where she reminds the court that she was trying to cross-examine the lead investigator about inconsistencies in his testimony. That against what an eyewitness supposedly told the first officers at the scene. Do you recall that? It was based on the differing descriptions of that getaway Jeep. Now, when she asked the question, the prosecution objected on hearsay. Judge Beresky sustained the objection without even letting Lori respond. She argued that the statement wasn't being used for its truth, but rather to show its impact on the investigation. She immediately asked for a sidebar, but the request was denied. Does this sound familiar? Because she said the same thing happened just days earlier on June 6th, but this time it was with a different investigator. And again, she tried to bring up what neighbors said they heard. They told police this in the early parts of the investigation, and the prosecution objected, saying that it couldn't be entered in. And the judge shut Lori down, sustaining the objection. There was no sidebar, and Lori claimed that she wasn't even given a chance to make her case. And she wasn't. The judge just sustained the objection. Well then, there's the issue of the sick investigator. And that investigator is her investigator. The judge asked Lori's advisory council to coordinate with her investigator to get the materials that she needed for court. But things didn't go as smoothly as Lori hoped. She claimed that the photos she needed weren't printed in time. And because of that, she couldn't conduct an effective cross-examination. Well, I don't know if you watch many of her cross-examinations, but I don't think they were very effective. Now, there were a few hits. There were maybe a bunt here and there, but there certainly wasn't anything that got close to the fence. And as if this all wasn't enough, she said the judge and the prosecution blocked her from introducing several exhibits which she felt were critical to show why Brandon Bedreau might have suspected her in the first place. But the court flat out wasn't buying it. And I think the court was erring on the side of protecting her rather than letting her bumble her way through it and open up doors that the prosecution really wanted to go after, but kept saying, I don't think Lori Daybell should go there. Well, the bottom line, Lori says the judge's behavior proves bias. It prevented her from putting on a full defense. Now, her argument was more than the court didn't like her. It was that the court didn't let her play by her own rules. Not at all. It almost makes you want to shout out that maybe that's why you should have gotten your own attorney, not acted like an attorney in a felony murder trial. Well then, she claimed that there was an alleged abuse of judicial discretion, and here Things went from procedural to downright puzzling to me. Daybell was accusing the court of abusing its discretion. But when you start to peel back the layers, the logic in her complaint, and this is all in my opinion, starts to fall apart faster than her jailhouse love stories and failing portals. Now, Daybell argued she was entitled to something called Rule 13.5, a hearing to determine probable cause for aggravating circumstances, and that should have happened before sentencing. The judge reminded her with a no, and he's not alone. He's backed up by Arizona law. 13.5 applies to pretrial determinations of probable cause, not separate little mini trials about sentencing factors after the fact. And this judge wasn't making this up on the fly. The real kicker here is that Lori Daybell made this request after jury selection had already started. That's kind of like asking for a rain check after you've already crossed the finish line. And here's another eyebrow raiser. She claims that the judge erred because he didn't bring the jury back into the courtroom to officially release them after the verdict was read. Now, did the judge get the jury dismissed? Absolutely. Now, did he possibly forget to do all of the discussion that we oftentimes hear? Things like, you can talk to reporters or other people, feel free to talk about the case. Well, perhaps. But is this really the kind of error that warrants a new trial? I mean, that's like asking for a refund on a steak dinner because the server didn't say bon appetit. It's procedural nitpicking. It's not due process. Now here's where things got a little messy. Lori claims that key forensic evidence, the DNA and gunshot residue, was introduced at trial without the proper foundation. She says the technician who collected the evidence was suddenly not testifying. And Lori says the state only told her about this in the mid-range of the trial. And worse, she said they failed to turn over the tech's full personnel file, which allegedly contains some negative material that she wanted to expose. Well, according to Lori, the technician had been implicated in some kind of workplace incident that led to her resignation. And here's the thing. The state did disclose that information, just not to Lori's liking. She wanted the whole HR file. That's that human resource file. And for people outside of the country, that's a personnel file. But the court just said no. And when the state later said 2 pages of the technician's notes were gone, that opened the door for Lori to object to other experts relying on that foundational work. But it didn't work because 3 other analysts ended up testifying on gunshot residue. Each testified using samples of data initially gathered by the technician, and it was all approved and done right. Lori objected, citing her right to confront the original witness, but the court overruled her. In legal land, this isn't nearly as outrageous as Lori tried to paint it. Courts routinely allow forensic analysts to testify to peer-reviewed results, even when the original tech isn't available. And that's all just as long as the method is sound and disclosed. So the irony here is getting pretty thick, isn't it? Lori wanted to represent herself, but now she's complaining that she didn't have the legal chops to fight evidentiary rules. She said the judge should have blocked the forensic testimony altogether. But I think most legal experts would say that this isn't how any of this works. This isn't CSI with a surprise lab tech plot twist. It's a courtroom, and the rules of evidence don't bend. They don't bend just because somebody's having second thoughts about going pro se. What might have happened if Lori Daybell had actually chosen to use a licensed lawyer instead of trying to do it herself? In my mind, there's no question that it would have been a more interesting trial. Because in short, Lori Daybell is arguing that she was denied a fair and impartial trial through no fault of her own. She's claiming she was forced to represent herself while seriously ill. And that repeated by the any means necessary command that the court gave, that repeatedly drug her into courtroom, amounting to a violation of her rights and depriving her of effective assistance of counsel. Now, she thinks the judge lacked judicial impartiality, and she's accusing him of bias. Allegedly, she wasn't allowed to respond to the objections. They were denied, sidebar discussions were denied in many cases, and some things were blocked. She was blocked from fully questioning some witnesses, particularly those connected to alternative theories involving Melanie Boudreau. Now, she also claims the court repeatedly threatened to expose her prior murder convictions if she pressed certain lines of questioning. They weren't threatening her, they were trying to protect her from her own stupidity. Now, it doesn't end there. Lori argues an abuse of judicial discretion by stating that the judge improperly denied her a hearing on those aggravating factors, that he failed to release the jury on the post-verdict, and he allowed DNA and gunshot residue to be introduced without the original technician's testimony. With all that, she says her Sixth Amendment confrontation rights were not allowed, and she couldn't confront her witnesses, arguing that she couldn't question that forensic scientist whose work others relied on. And she's arguing that she was forced to act as her own lawyer while she was too ill to do so effectively. And then, in typical fashion that we've come to see, she attacked the system by stating at the end of this whole thing, quote, "The state of Arizona does not honor the Constitution of the United States. The state of Arizona does not honor the constitutional rights of the accused or even the civil rights of the accused. And for this purpose, a new trial is required." Close quote. Well, I'd like to know your thoughts as we wrap this one up. Please drop your thoughts in the comments section down below, and don't be shy about jumping into the conversation with others. Just remember to keep it kind and respectful, because we're all here to learn and explore together. So thanks so much for watching Profiling Evil. Your support is deeply appreciated, and I hope you'll watch for us on Facebook, Instagram, YouTube, and Twitter. That way you can get updates, insights, and behind-the-scenes looks at the cases that we're covering. And hey, if you like getting your true crime on the go, make sure you're checking out Profiling Evil's audio podcasts on your favorite podcast platform. And if you're hungry for even more true crime, head over to profilingevil.com, where we've got interactive case maps, bonus content, and more. And make sure that you sign up for the BOLO, our digital newsletter, and that stands for Be on the Lookout. The only way you're going to get that thing is by signing up at profilingevil.com. And please take time to check out my true crime books online at profilingevil.com or on Amazon. And before we wrap up, I want to share something I'm really excited about, my new book. It's called Wolves in Sheep's Clothing, and it's finally here for pre-orders. It's unlike anything I've ever written. The book pulls back the curtain on how predators hide in plain sight, how they manipulate, groom, and control, all while wearing a mask of normalcy. So whether you're a true crime enthusiast, a concerned parent, or just somebody who wants to better understand the dark side of human behavior, this book's for you. And here's the cool part. You got 3 ways to get your hands on it. First, for the serious collectors and Profiling Evil superfans, I've set aside 100, only 100, hardbound, signed and numbered author copies. Once these things are gone, they're gone. And these are exclusive and only available through profilingevil.com or the link that's down below, which will take you to profilingevil.com. Now, second, you can go to profilingevil.com and pick up a signed copy directly from me in hardbound or paperback. And for those of you that just like to listen, you can go ahead and you can get the audio version, or you can get it on your Kindle device. And by the way, if you purchase the books from profilingevil.com and you live in the United States, I'll ship it to you for free. And then the last way is for all of our international friends, or for anyone else who just wants to do it this way. Amazon's got you covered. Just search for Wolves in Sheep's Clothing by Mike King and order it wherever you are in the world. Books will start shipping on July 7th. So however you choose to read Wolves in Sheep's Clothing, I just want to say thank you. Your support keeps me going. It keeps me telling stories, honoring victims, and most importantly, helping spot the wolves before they strike again. I can't wait to hear what you think of the book. So let's keep profiling together. Hey, we'll see you soon at the next crime scene.